Good afternoon for those on the East Coast. My name is Peter Kahn, and when my husband Donald and I were planning our wedding, we had to speak to all the fun vendors, the photographer, the caterer, the calligrapher. Plus, we also had to make plans to speak with more serious folks, the accountant, the attorney, and the financial planner. And that's because at the time, our marriage was recognized in Massachusetts, but not at the federal level. And I still remember, though I don't fully understand, the diagram that our estate attorney drew for us on his yellow legal pad, filled with boxes and arrows, showing this multi-part trust that he was proposing to help us shield our assets so that we could be sure that the organizations that we cared about continue to receive our support. And one of those organizations that we're proud to support is the Boston Public Library Fund. It's through the work of the fund that the Boston Public Library is better equipped to fulfill its mission to provide free access to high quality information and resources to all. And one area where we can certainly benefit from clear information is estate planning for same sex couples and non traditional families. Even though the federal government now recognizes Donald's and my marriage, we want to be prepared to defend our lives together against people in power who would like to deny the worth of our love. So, to help arm us with the truth and some relevant resources, I'm pleased to introduce our speaker, Scott Squillace. Scott has over 38 years of experience as a business, tax, and estate planning attorney. He founded Squillace and Associates, PC, a boutique law firm in the Back Bay. He served on the board of directors for the Boston Foundation and the Boston Estate Planning Council, and he's the author of Whether to Wed, a legal and tax guide for gay and lesbian couples. So just as a reminder, we are in a webinar format and we're being recorded, which just means that we can't see you. We're going to rely on the Q&A box down at the bottom of your screen to collect your thoughts. And with Scott's permission, I'll be able to interrupt him during the presentation to ask clarifying questions. If there's anything in particular that you want to be sure that he covers, I encourage you to use the Q&A box now to let us know your interests. And then a little after 1 p.m. Eastern time, I'll jump back on and I'll moderate some more questions until we end around 1:25. So please join me in welcoming Scott.
Thanks, Peter. What a nice introduction that was. And thanks to the team at the Boston Public Library who put this together. I've been very impressed with your organizational skills and your commitment to providing information to the public. As Peter mentioned, I'm an estate planning lawyer. I work with some colleagues in the Back Bay, and I always jokingly say we don't discriminate. We work with straight people too, but our practice is focused in large part in our community. And about our community, before I even dive in, I want to just a word about terminology. By last count, I think we're up to 10 letters and symbols to identify our community. LGBTQIA 2S plus. If anyone's not paying attention, the 2S is dual spirit to include indigenous peoples demographic. But I am a little old-fashioned and can't spit out the alphabet soup every time. So please permit me to say gay or LGBTQ plus from time to time. And I don't mean to exclude anyone, but just shorthand it for convenience. But I intend to be inclusive in this presentation for our entire community. Let's see. I want this slide to move forward. It's not working. Oh, there we go. Okay. There was a little delay. So we're going to do three things. I'm going to give you a little overview of where we've been and where we are in terms of the legal landscape. I probably have twice as many slides to cover than we have time to cover. So I forewarn you that I'm going to do some drive-by with some of them, but I included them in the materials. So to the extent people want to refer back to them afterwards, there'll be more information for you to be able to dig into. We're then going to pivot to some practical tips around life and estate planning for same-sex couples, including what I have dubbed the whether to wed conversation. And then we're going to also talk about some tips around legacy giving. And again, Peter mentioned at the outset that if there are particular things that you want to hear about or questions you have, please feel free to already put them in the chat so we can make sure we cover them. I'm trying to move this slide forward. Let's see. I apologize here. I don't know why it's not moving. I mean, I may need some help from the team here.
Yeah, I just provided access. There we go.
Okay,
Does that
thanks
look
very
good,
much.
Scott? Okay, you're
Yep,
welcome. Good
it
luck.
worked in our practice session.
It sure
All
did.
right, so just to sort of orient us, the sort of beginning of what people think of as the modern gay rights movement really started in the summer of 1970 when the Stonewall riots happened, and shortly following that was actually the very first case brought in federal court before for a same-sex couple. Many people, until we had the Obergefell case, didn't realize that was on the books because the Supreme Court denied review of it way back in 1970. But that was really something that flowed from the modern gay rights movement. Boy, these slides are going to be a challenge today here. Carol, I really may need someone to move the slides. Okay, here we go. Let me know if you're doing it or I'm doing it because mine doesn't seem to be working. Okay, so there was that first case back in 72, but it wasn't really until the early 90s when the movement started to gain some traction. And for those who were around or paying attention may remember that it was in Hawaii where the first case was actually initially successful in a lower state court about giving rights to same-sex couples. And it was being appealed to the state's highest court when people got concerned that Hawaii was going to become sort of the Las Vegas for gay marriages, and everyone was going to be going to Hawaii to get married, and that was going to be disruptive from a federal perspective, because up until then, every state's marriage had to be recognized in other states and for federal purposes. So it was the result of that Hawaii case that the Congress enacted something called DOMA, Defense of Marriage Act, defining for federal purposes marriage to be recognized for federal purposes only between one man and one woman. Then President Clinton signed that into law, and that was the law of the land for quite some time until the Windsor case, which we'll talk about in a minute. But Hawaii sort of settled the cases and never really landed on one side or the other. And it wasn't really until the next case that was brought by Glad Law in Vermont to try to prove the concept that everyone had a right under state law to become married. And that case went up to their highest court, and they kind of punted a little bit by saying, well, we think that everyone should have the same rights and privileges. We just don't think you have to necessarily call it marriage. And from that case was born the concept of civil unions. But it was really only applicable in the state that had it. So a lot of couples went to Vermont during that period to have a civil union ceremony. And it was frankly more emotional and relationship oriented than legal oriented, because the civil union status stopped at the borders of Vermont and were only recognized within Vermont. It wasn't until 2002 when the case was filed in Massachusetts. It was actually decided in the fall of 2003 and became effective May 17th, 2004. But it was really the watershed landmark case, Goodrich versus Department of Public Health, that established the principle that under the Massachusetts state constitution, there was a right of same-sex couples to be married. And I've read a lot of these decisions over the years, and I still always come back to this one. So if anyone is a little bit of a legal geek and wants to learn about the reasoning of why this is constitutional, I commend you to read that decision. I one time had the good fortune of meeting Justice Marshall, who wrote that opinion, and I thanked her for it. And her reply was pretty profound. She said, "Don't thank me, thank John Adams. He wrote your Constitution. I just interpreted it." I would like to go to the next slide if we can. Thank you. So then following that watershed moment in Massachusetts, there was a variety of things that happened all over the country. Some states passed mini DOMA laws saying that under no circumstances would a same-sex marriage be recognized in their state. Other states had cases. And to Peter's opening remarks, we then lived in a world of patchwork where some states recognized it, other states didn't, and the federal government didn't. And so it was a little bit confusing from a planning standpoint. If we can go to the next slide, please. So the next slide, wish I could move these myself. Oh, maybe I'll try that. Okay. Um, and that led to having, because there was sort of a bunch of differing opinions around the country, the first case landed on the steps of the Supreme Court, and that was the Windsor case. And for those of you who don't know, that was a pretty simple factual case. Edith Windsor had been married to Thayer Spire for decades, and they had developed a life together. And at the time, Thayer got a horrible diagnosis, and they wanted to be married before she passed away. New York didn't allow it at the time, and they went to Canada to get married. And that Canadian marriage, they claimed, should have been recognized both in New York and federally. And it wasn't recognized federally because of the Defense of Marriage Act. And so they sued, saying, we think it should be recognized because we shouldn't have to pay an estate tax. There's an unlimited marital deduction on estate taxes for spouses. And they prevailed. If we can go to the next slide. In a 5-4 decision, Justice Kennedy, writing for the majority, determined that based on substantive due process and equal protection grounds, that the federal government had to recognize marriages that were valid in a state, irrespective of gender, and otherwise would be to violate due process. But it was really limited to that decision, meaning, if we can go to the next slide. The opinion was confined only to those lawful marriages, meaning they weren't saying that marriages had to be recognized in any state. And by the way, I failed to mention, but marriage has always been, like all family law principles, divorce, adoption, and so forth, governed by state law, not federal law. But there are federal consequences to being married, all sorts of ones, over 1,000 rights and privileges, Social Security, survivor benefits, and so forth. And so it said basically, we will agree that if you are validly married in a state, the federal government will recognize it for federal purposes. But if a state doesn't want to recognize it, we're not going to have to recognize it either. If we can go to the next slide, please. So, so after Windsor, there was more litigation trying to determine whether or not there was a constitutional right under a federal constitution to become married. If we can go to the next slide, please. And that gave rise to the Obergefell case. Next slide, please. That was argued a couple years later and decided precisely 2 years after the Windsor decision, also successfully. And the questions were basically whether the 14th Amendment required states to license marriages between two people of the same sex, and whether it also required states to recognize marriages of two people between the same sex once validly performed, if in another state. We can go to the next slide. So that also was decided by Justice Kennedy, based on similar principles. And they rejected the notion that they were creating a right to same-sex marriage. They relied on precedent cases that had come before the court in prior years, most notably the Loving case that said interracial marriages have to be allowed. But there were other cases where they determined that you had to, if you were an incarcerated person, you were still allowed to be married, or if you still owed child support, you're still allowed to be married. And they basically made the point that marriage is a fundamental right, and it's not gay marriage, it's marriage full stop between two people. If we can go to the next slide, please. So, so that sort of settled the question nationally around whether or not we had a right to be married, and all of the anti-marriage statutes and constitutional amendments became invalid, unconstitutional. And if you think about what happened with Roe v. Wade and the Dobbs decision, there were laws on the books in different states outlawing abortion, and when Roe was determined, those laws became invalid. And when Dobbs overturned Roe, we went back to having a patchwork of allowing states to regulate it differently. And it's possible we could have the same thing here. I'll talk more about that in a bit. But Obergefell really settled the law around same-sex marriage. and made it clear that every state had to both allow it and recognize it. So then we still have had a serious putback both culturally and politically around our rights. And one of the first cases that made its way back up to the Supreme Court was the cake baking case called Masterpiece Cake Shop. And it was a bad case. And there's a saying in law school, bad cases make bad law. But basically here, a private baker was being asked to bake a cake for a same-sex couple. And there was a claim that it violated the Colorado Civil Rights Act. And the court determined on really narrow grounds, next slide, please, that it was really because the lower court was arguing discrimination based on people's beliefs that they were allowed to not have to bake the cake. It didn't really have a great deal of precedential value, and they kind of straddled things. And it wasn't until the next case, next slide, please, which was really a First Amendment case around a website developer not wanting to do a wedding website for same-sex couples, that the court agreed with the plaintiff there to enforce the challenge against, again, it was the California discrimination statute saying, next slide, please, that you can't really violate people's First Amendment rights. And therefore you can't be forced to make a website that's against your firmly held religious beliefs. So this is kind of a very pointy head constitutional law conflict between the First and 14th Amendment, and that's how they came down. There are other cases, and I'll talk in a minute about some of them that are percolating up through the system where this is the other angle that they're trying to sort of use to backtrack some of the rights. If we can go to the next slide, please. Next slide, please. The big one that was in the news recently was the Kim Davis case, and she's been in the news for quite some time. Kim Davis was the county clerk in Kentucky who refused to issue marriage licenses to same-sex couples, even after the Supreme Court determined that every state had to allow that. And she was held in contempt, she was fined, she was jailed, and that she appealed all the stuff to the Supreme Court saying, I think this is all wrong and I've been harmed. And oh, by the way, I think Obergefell is wrong and you should overturn it. When the Supreme Court considers cases for a review, there are basically two ways. One is mandatory jurisdiction, like disputes between states or governmental officials, and the other is discretionary jurisdiction called a petition for certiorari. And I forget the numbers, but I think they accept about somewhere between 10 and 20% of those discretionary cases. And this was one that was put before them, and they just denied to review it. So there was a lot of noise in the press about the fact that same-sex marriage is still secure. It is, but it doesn't mean that it can't be challenged. It just means this particular challenge they decided not to take up. And to take up a challenge, 4 of the 9 justices have to agree, and they didn't have 4. There's a whole longer conversation about whether Obergefell may be overturned and what that could mean to us, but we should take some comfort in knowing they denied certainness, but it doesn't really dispose of the underlying question of whether they could change their mind on Obergefell in the way they changed their mind on Roe. If we can go to the next slide, please. And I'm going to try to speed it up a little bit. Next slide, please. So we're going to skip past a bunch. Next slide, please. So there are some other important federal cases that I just want to call out because they really speak to our ability to have legal rights. And this first one was a big one under Title VII, which is the employment non-discrimination law. For years, there was some confusion about whether the provisions in the statute that said you can't discriminate in employment based on sex included sexual orientation and gender identity or just meant gender. And in fact, because there was such confusion about that question, for a number of years, people tried to get Congress to amend that statute to be clearer that sex included sexual orientation and not just gender identity. All of those attempts to amend the statute in Congress failed ultimately. Sometimes it passed the House and not the Senate or vice versa, but it never made headway. And frankly, I was a little surprised by this ruling and its author. But next slide, please. Justice Gorsuch decided that in fact sex includes gender orientation, sexual orientation, and therefore you can't discriminate employment-wise based on that. So it was a big win for the community. But there were some other losses that occurred along the way too. And here again was one where the First Amendment was bumping up against the 14th Amendment when the Catholic Social Services from the city of Philadelphia sued because they didn't want to issue licenses for foster homes to couples that were of the same sex because they thought it was against their deeply held religious beliefs. And again, the court erred in the favor of protecting the religious beliefs here. We can go to the next slide, please. I'm going to try to work these if I can. This is really here for your reference, but there are three different constitutional standards for reviewing things, and what standard is being used helps determine the ultimate outcome. And we've sort of migrated as a community from having the lower standard apply to the higher standard, but it's not entirely clear that the highest standard applies in all cases. It does for First Amendment stuff. The Skermeti case was having to do with providing medical care for gender dysphoria for minors. And here the court really held in favor of the parents' right to make medical decisions for children. Though it was considered to be a case around transgender rights, it was really about medical decisions for minor children. And so we still have other cases percolating up, one that was heard this term and not yet decided around transgender people in sports. So we're still evolving what the Supreme Court is saying about those issues. Next slide, please. Next slide. Next slide.
Scott, I was just going to say we have about 10 more minutes, and there's some questions coming in about the estate planning side of things. So I
Okay.
wondered if you want to
So,
prioritize that.
thank you. Let's skip past the rest. Well, the only thing I want to say about this is that we're in a bad zone right now, right? It is not news to anyone that the Trump administration has followed almost precisely what was in Project 2025 and issued a whole slew of executive orders that are very oppressive to our community, and they are all in different ways being challenged. So stay tuned on that. If we can go to slide number 54, please. That would be a good place to start around the planning tips. And I apologize because there's lots here and lots happening. So we're going to slide number 54 on the deck. Yep. So we're going to cover a few topics here: life, disability, and death planning. Go to the next slide, please, and the next slide after that. You know, it is not uncommon for same-sex couples to own property together. If they're unmarried, it's really important to consider joint ownership agreements. People sometimes don't realize that when they take out a mortgage together, they're liable jointly and severally. If the relationship breaks up and someone stops paying, unless you have a contract, you're not both required to still pay. Each of you, the bank can look to either of you to pay unless you have an agreement. So those are important when you own property or not not married. There are other things to consider, and I'm not going to dive into all these, but this is just by headline news. If you've been together a long time and maybe have different assets, you should consider prenups. Obviously, it's a whole other discussion around assisted reproductive technologies and how we plan for and have our families. The big headline news on that is, given the fact that we're in a world with hostile states legislating now against us, it is the best advice in the bar these days that people do a second parent adoption, even if you're in a friendly state like Massachusetts, because if you ever travel to a hostile state like Florida, your parental rights might be questioned. If we can go to the next slide, please. The other stuff that we always recommended people do is still important to do. Powers of attorney, healthcare proxy, HIPAA releases, make sure you're getting your insurance in order. Even if you're still now married and enjoy all the rights and privileges of marriage, it is better to have these things in place in case our marriages are ever challenged in states that don't recognize our marriage. And you happen to be in those states when the bad thing happens. Go to the next slide, please. Other things to consider in terms of planning is the death planning. And at a very high level, you have two choices. You have three. Do nothing, do a will, do a trust. The do nothing is obviously the least good option because it takes more time and costs more money to get things done. And you only have to follow the statute in terms of relationships of who receive your property. If you do a will, that's better, but it's also easier to contest a will than it is a trust. And it takes longer and costs more money to administer a will because it necessarily involves the court supervised process of probate. Whereas a trust, I have a bias towards this, doesn't need to go through probate, is much harder to challenge, and allows for cascading beneficiaries, which I'll talk to in a minute. Go to the next slide, please. Um, I, I'm going to come back to the legacy giving in a minute. So if we go to the next slide, please. When you're thinking about planning, if you take nothing else from this slide, please take this, and that's the boomerang. So when lawyers go to do estate planning in law school and in seminars, everyone draws these lung charts, husband, wife, everything to each other, then to the kids equally. Well, guess what? Not every family has kids. Now, I know increasingly, someone told me the other day there's a baby boom happening and we are having kids, but there's a huge cohort in our demographic that weren't allowed to be married, and it wasn't as common to create a family, and so don't have kids. And so it's very common for couples to want to provide for each other. But I like to use myself as an example. I'm happy for all of my assets to go to my husband if I predecease him. But if we're in the same car and he only survives by 6 months, I don't necessarily want them all to wind up with his brother. I want them to boomerang back to my nieces and nephews. Another way to talk about it is sort of having cascading beneficiaries. So you can do that in a trust and you can't do that in a will. So if you have an idea of wanting to provide for a partner or spouse, but then maybe some others that are different with what's left over from what your spouse or partner may want to do, the only way to accomplish that is through trust-based planning. And obviously you should talk to your advisors about that and get advice. There are other reasons people do trusts. It helps with some tax planning. It helps with some asset protection planning. Obviously, if you do have children, they need to be provided for. I hear a lot of lawyers these days say, well, now that we have same-sex marriage recognized in every state, there are no differences in the planning. Well, there still are some differences because we sometimes create our families through assisted reproductive technologies, and we have to look carefully at how we define not only children, but descendants in these trusts to make sure they're included and not excluded if there's not a biological connection. And the last point I'm making here is about possible challenges to marriages. You know, we're currently drafting our documents to say so-and-so is my spouse and shall be recognized under this instrument for all purposes as my spouse, whether or not it is administered in a state that recognizes our marriage. So we're kind of preemptively planning for the off chance that marriage goes away. If it goes away, and let me talk about that for a minute, it doesn't go away everywhere. It just goes back to this patchwork where some states may recognize it and other states may not. And I did skip past, but the important development that happened under the Biden administration was the Respect for Marriage Act, which I think has been a little bit confusing in the marketplace. It doesn't mean that the federal government has said that there has to be same-sex marriages allowed in every state like Obergefell does. It just means that Windsor, if it's overturned, is still going to be protected by the statute. Because Windsor said if your marriage is valid in some state, then the federal government has to recognize it for federal purposes. And that's essentially what the Respect of Marriage Act said. If we can go to the next slide, please. Another thing that people often forget about and was very acute during the AIDS epidemic is this notion of who has authority over your remains after you've passed away. There's a little bit of an urban myth out there that if you hold a power of attorney for someone, you can deal with their remains. That's not true. A power of attorney ceases to be effective at death, and unless you've done a special type of power of attorney that's called designation of agent for remains, you do not have authority over your partner's remains. And in relationships where you've chosen not to be married, That becomes important if there's hostility among the biological family, because the law says, absent one of these, your next closest relative has authority over your remains. Now, if you're married, then you are the next closest relative. But if you're an unmarried partner, your next closest relative is either your parent or sibling or child if you have one. So it's important to think about that. I guess the other little practical tip is about updating beneficiary forms. People often forget to do this. It is not uncommon in our world and in other worlds to have multiple relationships during your lifetime, and you might have designated someone as the beneficiary of a retirement plan or a life insurance policy with a prior relationship. That's broken up. You've gotten married. You forget to update that. Someone passes away. You can't change it. Who's ever on the form is bound by contract to be the beneficiary. So be sure to update that. If we can go back to the slide on legacy planning quickly, which is slide number 58, I would appreciate it. I'm going fast to make sure we cover everything, and I do want to leave time for questions. If you could go to slide 58, please. You went too far. Slide 58. Here we go. So legacy tips. The first thing to think about is, I always jokingly tell all of our clients, death is the biggest liquidity event you ever have. No one ever thinks their estate as big as it is because it's not sort of cash in your checking account. But if you've owned real estate for some meaningful period of time, particularly in our part of the country, there's been huge appreciation and equity built up in that. You have typically retirement plan savings and other things that are illiquid that after you're gone get sold and all become liquid. So when you think about sort of whether or not you have enough to do legacy planning, I always encourage people to think about it sort of in the alternative, because you never know exactly what's going to be left over. You don't know whether you're going to have a long-term catastrophic illness, so the numbers on the page are different. But you can apply some formula clauses that say something like, as long as there's at least X left over in my estate for parentheses, spouse, partner, kids, friends, family members, then I'm okay with Y going to ABC charities like the Boston Public Library. You can also just pick a percentage of what's left over after spouse or partner are gone and say that can go to charities, and you don't even have to necessarily come up with a list, although it's always good to have a list that includes Boston Public Library, but a formula clause that I like that requires you to not have to keep updating it is to say, please give whatever percentage, 10%, to whatever charities I had most recently been giving to in the last 3 or 5 years of my life, as evidenced by my tax returns. So that assumes you do current charitable giving, but if you do, and those change over time, this allows you to have sort of a rolling list that's baked into your plan. There are other more sophisticated tools for charitable planning out there that really involve income tax planning during lifetime. If you're going to have a big liquidity event like selling a business or receiving a big inheritance, that's the time to think about some of these other tools and techniques. But a really good way to think about it is just take a percentage of your retirement accounts. That's the easiest tool to do charitable giving because it's the most tax efficient, whether it's 1% or 5% or 10%, and have that go to your favorite charity. So there's all sorts of techniques that you can apply besides just listing so-and-so gets X amount or X percentage. So with that, I'm going to pause because I know I've sort of bounced around and covered a lot. Oh, I want to go to one more thing before I pause, and that's the weather to wed. So if we can go to slides 61 and then 62 quickly, I would appreciate it. And I promise I'll be done in 2 minutes, Peter. Go to the next slide. So look, after gay marriage became available to us in Massachusetts on May 17th of 2004, there was a whole cohort of people who had been together for decades, and as I say in my book, had already figured out who's taking out the trash and who's paying for what, and basically didn't need to become married for their personal relationship reasons. And they would come to me and say, look, unless you tell me there's some legal or financial or tax reason why I should be married, we don't need to get married. And so I developed this list of pros and cons that exist on the federal level and the state level that people can look at and then give whatever weighted importance they want to each of those pros and cons. But the most important one that people tend to focus on is the income tax issue with marriage, and that is commonly referred to as the marriage penalty. So it's common that if one person makes X and the other person makes Y, and you get married and file jointly, you get to the higher marginal rate quicker, and there's a marriage penalty. You're winding up paying more federal income tax as a married couple than you would have each individually as a single couple. By the way, there's a little bit of an urban myth that if you're married, you can avoid that problem by filing separately. That's not true. You can file separately, but your tax treatment is still as if you were a joint, and your itemized deductions are phased out quicker. So it's generally not a good idea if you're married to file separately. But anyway, there could be an income tax penalty for becoming married. There's also a potential income tax bonus. If one person makes nothing and the other one makes a lot, your effective rate might be lower. But the thing I want to leave you with is there's a big difference between the income tax system and the estate tax system. If you are married, the estate tax is zero. And if you're not married, there might be an estate tax on the state or federal level. And the government doesn't care whether your assets are in your home or in your retirement account. They apply this tax after death to any person who's not a spouse. In Massachusetts, that level is very low at $2 million, above which there's a 16% haircut. So I'll stop with that and pivot to the questions because I know there are some percolating it up and I want to make sure we get to those.
Yeah, I appreciate that, Scott. I know I have at least five here teed up for you, and we have about 15, 20 minutes left. So I'll start with you were definitely sharing with us the benefits of a trust. One of our participants wants to know if this person has no living parents, no partner, no kids, and they do nothing, what happens? Who inherits and who handles the estate?
That's a great question. Well, under the law, your next closest relative would have a right to make a claim. Of course, they would have to know about it and figure it out. There are air search places that can find the second and third cousins once removed. But if no one comes forward, after a period of time, I forget, I think it's either 7 or 9 years, all of the assets sheet to the state and become abandoned property and then are parked there for some other meaningful period of time, like 10 or 20 years, and then the state can just take it and use it for whatever they want. So if you do nothing and you abandon your property at death, anyone who has an interest in your estate can come forward, which includes a creditor, by the way. They could try to open the estate to get their bills paid, and then it's their obligation to go find these heirs that are distant relatives. And if no one ever does that, it sheets to the state.
Hmm.
Does that answer that
Yeah,
question?
it sounds like so. If you want control or some say in where your assets go, you're better to be protected with some legal preparation.
Yeah, and by the way, that fact pattern is one where you probably don't need a trust. Like if there's no other cascading beneficiaries you need to provide for, and you're happy for it to go to either ABC Charity or XYZ People full stop, then just do a will.
Hmm. Got it. So this is again about this. I think the whether to wed question. Another participant asks, uh, well, what about just doing the estate planning and not the marriage? Are there benefits to that arrangement?
It's sort of a weird question, but let me try to take it apart. Whether you get married or not is both a personal decision and frankly, a tax planning decision. By the way, let me just say one other thing about the whether to wed, and that is we tend to blur in our society the concept of weddings and marriage. Like when I have this conversation and people conclude that their estate tax situation would be better if they were married, they start saying, "Oh my God, who are we going to invite and where are we going to do it?" You don't have to have a party. You can go to a justice of the peace and never tell anyone besides your lawyer and accountant that you got married. But that's really separate from whether or not to do an estate plan. If you have any assets that you want to go anywhere in particular, you should do an estate plan, whether you're married or not. The effect of the marriage really is a whole host of rights that then are governed by statute and some better tax treatment on the estate.
And what about domestic partnership? One participant wants to know, is that still a category and how does that, what benefits does that allow?
Yeah, great question. That's one where there's a little bit of confusion in the marketplace. I still hear people say, I'm a domestic partner. Well, you were under the prior law when it was in effect. But once Obergefell came into effect, that went away in most states. There are some states, Massachusetts is not one of them, that either on a state level or on a municipal level allow registered domestic partners, and those states have statutes that define what that means. But for all practical purposes, it's meaningless for us in Massachusetts, and either you're married or you're unmarried. And by the way, if you're unmarried, um, there's a whole host of consequences that flow from it that really only emerge when the bad stuff happens. So I'll tell my quick story of my couple who were both professors at major universities, smart people, and unmarried during the period when marriage was allowed in Massachusetts, but not federally, because they felt like it was marriage light. Something horrible happened to one of them when he went to the ER with chest pains, and he was told it was antacid, take some Rolaids and call us in the morning. You can see where the story is going. He had a dissected aorta, died at work the next day, and they were unmarried, but they thought of themselves as, they'd been together 17 years. They co-owned a property together. The decedent's mom, who was the next closest relative to inherit, said to her son-in-law, "You can have everything." Well, there were gift tax issues with that. The son-in-law wanted to consider a malpractice case. Well, he was a legal stranger, so he had no standing to bring the case. He also wondered whether he was eligible for a workers' comp claim because he was a spouse and he died. The guy died at work, and no, because he's a legal stranger. So keep in mind that if you're together with someone and your life is kind of combined economically and otherwise, if you're not married, all of your rights that you might otherwise have sort of fall away. So there are other compelling reasons besides tax that benefit from marriage only when bad stuff happens.
Hmm. I have a few more questions along those lines of people in different states of marriage or unmarriage. So someone asks, they are not currently married to their partner, but they do have a will. Would they also need a trust to put some of the real estate assets in, or how does the trust and will work together?
Yeah, let me talk about that because maybe I didn't explain it well in my haste. A will and a trust both do the same thing. They make sure everything gets where it's supposed to go. A will makes sure it gets where it's going full stop, and that's where it lands and it's done. A trust allows you to park things for someone's benefit, like a spouse or partner, and then allow what's left over to cascade down to other beneficiaries. So when you do a trust, by the way, you still do a will because the will says, if I die with anything in my name, please put it in my trust. But when you do a trust, you are advised to put things in your trust during your lifetime so you don't have to put them in the trust later by probating a will, just to save time and money on the postmortem administration. But whether you do a will or trust really depends on what your wishes are about who gets what, when, and under what circumstances. If you want to provide for one person or one entity and there's no one after that that you care to provide for, a will is a great solution. But if you have other people that you might want to use up the rest, then a trust is the better solution.
Hmm. So another participant asks about a scenario where they're considering marriage, the partner has dementia and may be going to a nursing home. Does it make, how are you going to protect the assets in that case?
Great question. And because I breezed by it, there is a slide on this in the materials. But when you look at the pros and cons of marriage, one of the cons is that if you needed to apply for Medicaid coverage for skilled nursing home for an elderly person, both people's assets and income are countable for determining your eligibility for that. And keep in mind that Medicaid is the federal coverage essentially for indigent people. You have to have virtually no assets left over for that to kick in. Otherwise, they wind up putting a lien on the house. And there are other techniques to protect the house that I'm outside of the scope of this presentation, but Google elder law planning and you'll learn all about it. Um, but basically, the questioner is correct that if you are considering needing someone to have care in a skilled nursing facility and you want the government to be able to pay for it, then don't get married.
Hmm.
And there's also an issue in that fact pattern about whether or not the person who's suffering from dementia has the capacity to enter into any legal document, whether it's a will or trust or power of attorney. And that is determined by certain legal standards and case law that the lawyers should know about and will have to evaluate. And if, by the way, it is determined that the person doesn't have capacity, the law provides for a separate process for a probate court judge to order a will or power of attorney to be done on behalf of an incapacitated person through a guardianship proceeding. So again, that's its own Pandora's box.
Got it. So
But let me
several.
just say one other thing about that, and that is try to do your planning before you become incapacitated. Like no one ever knows when that's going to happen. And I tell everyone life is like a bell curve in terms of people living natural life expectancy and at certain ages. But every once in a while, weird things happen earlier on. And so I like to or encourage people to do it when you're alive and well and not in crisis.
So about 8 more questions and 10 more minutes, so we'll try to go speed round. A participant asked about revocable trust. What goes in there and maybe help define it?
I kept talking about trust and I shouldn't have said it like that. What I meant was a revocable living trust,
Hmm.
meaning it's changeable. You're your trustee during your lifetime, you're your beneficiary, and you're supposed to put everything in it. And it's like taking your assets from your right pocket and putting them in your left pocket. They're still yours to freely do with whatever you want during your lifetime. But now that they're there, we don't have to go through probate to get them there. We just have to have the next trustee take over, think executor, and do whatever the trust says needs to happen. There are other types of trusts that are irrevocable that are done for other reasons that are outside of the scope of this presentation.
All right. Someone asks very practically, what if you keep changing your mind if you where you want to direct your assets? How do you take that sort of future uncertainty into account?
It's the Full Employment Act for the lawyers. You keep updating your will or trust. And I didn't mention this, but one of my favorite questions is, well, can I just use LegalZoom.com? You absolutely can, and it might work. You'll never know because the only time you go to use this stuff is when something awful has happened. And I've had the fortunate or good fortunate experience to have to deal with some legal Zoom documents that were incorrectly done, and we had to go to court for modifications, which cost way more than it would have cost to just go to a lawyer to start with. But if you change your mind, you update your plan. You update your beneficiaries. It's in effect for whatever it says until you change it.
So here's a scenario of a married same-sex couple. One of the spouses is a birthing parent. What legal steps should the non-birthing parent take to ensure equal rights?
Second parent adoption. Absolutely. There's, and in the materials, there's a case that is an important one where the law always deemed any person born into a marriage, they deem it to be a product of a marriage, and both people who are the spouses to be the parents of the person. There was a case, I think it was in Pennsylvania, where a lesbian couple got divorced, and one was the biological parent, and the non-biological parent was being challenged about her parental rights, and the court said, no, no, no. The law applies that the person born to the marriage is a parent of the person, whether or not it was a biological product. But that is in what I'll call a friendly state. There are what we're calling hostile states where that is decidedly not the case. Massachusetts is not surprisingly a hostile state, but a whole bunch are. And so if you travel to or live in one of those states, your parental rights could be challenged unless you had a second parent adoption. And then under the full faith and credit clause of the Constitution, that court order has to be recognized by the hostile state. It is a little upsetting for families to have to go through that because it requires home visits and other things that people feel like they shouldn't do when they're really the parent, but it's the price we pay for the additional protections we need given the uncertainties these days.
So here's another uncertainty related question. Given the Trump administration's treatment of trans people, this is someone who is a trans man married to a cis woman. What are the protections this person can do to prevent this marriage from being invalidated through the lack of recognition of trans identity?
Yeah, it's a great question. We have a lot of trans clients. There's no easy answer except to do your planning with a competent lawyer and make sure that the additional drafting is in place. I'm a member of the National Gay and Lesbian Bar Association, and we are on a listserv where these kind of clauses fly around all the time. But people who are really close to this are developing some unique language that we think should work. but none of it has been challenged yet because we haven't had a death and a challenge. So the best I can tell you is work with someone who's really familiar with this stuff and do your planning.
Got it. Here's another planning related question, particularly if the country reverts to that patchwork system again that you mentioned. Does it matter which state issued your marriage certificate? And if, say, if you own property in a certain state, should you be married in that state? Or if you have your Massachusetts license, how does that apply?
Yeah, it's a great question. There's not an easy or simple answer to this because there's a bunch of levels to the inquiry, but there there's also an aspect of whether if first of all, if you're a resident in a state, you're entitled to be married in that state if that state allows you to be married. So that's the starting point. There are some states um, that had a residency requirement to be married. Massachusetts was one of them initially, and that changed and got fixed. But it is not uncommon for someone to be raised in one state and live in another state and want to go back to their home state because they want to get married in their home parish or I don't know, whatever. And people do that all the time. So as long as you're allowed to be married in the state and the state recognizes your marriage, then you can get married wherever you want. Go to Las Vegas, go wherever you want. But if we get to the point where we have patchwork, then you have to get married in a state that recognizes your marriage. And that if you're not resident in that state, recognizes it as a non-resident. Where you own property is a whole different kind of kettle of fish, but that basically gets fixed by doing a proper trust and deeding the property into the trust. I can get into the mechanics and the whys of that, but that's how you fix that.
Got it. Time for just a few more, and I'll try to get through the ones our participants have posted here. So this is talking about estate taxes. Are single people taxed at higher rates than married people? What is the estate value threshold as it relates to marriage?
So again, there's a state estate tax and a federal estate tax, and these numbers move around when legislative tax policy changes. For many years in Massachusetts, it kicked in above $1 million, and about 3 years ago, Governor Healy proposed and the legislature adopted a thing to make it 2 million. And federally, it's bounced around all over the place, but it's at historically high levels now at 15 million. So anything above those numbers at the state level gets taxed at 16%. Above 15 million, nice problem to have, gets taxed at 40%. If you're married, you can double those amounts up through the trust planning because these amounts are essentially a credit that you either use or lose at death. And another advantage of doing trust planning is because you never know who's going to go first. Whoever goes first can use his or her credit so that when the next person goes, they can use his or her credit. And there's the tax only kicks in above the threshold amounts. And that tax only kicks in for anyone other than a spouse. So to this questioner's question, if you're single, it's going to kick in if you're at those thresholds because you don't have the ability to double it for anyone other than a charity. If a charity is receiving, there's no tax. So that's another way to mitigate the estate tax.
The Boston Public Library Fund approves of that. Here are two questions, if I could combine them. This is a person asking about a queer couple, in this case, trans man and cis woman, adopt a child. How does marriage status affect that? And then someone asked about, can the court assign guardianship to a non-married partner?
Okay, so let me just first say I am not a family law expert. So what I'm about to say may or may not be correct. So you should take advice from a family law expert. My favorite one in town is Joyce Kaufman, who is one of the national leaders in this space. But let me try to take it apart a little bit. So parental rights can stem from having a child during the course of a marriage, like I talked about earlier, but don't have to. Two people can adopt a child and they're the parents. And that doesn't mean you have to get married. You might choose to get married for all sorts of other reasons or not. Um, yes, a court can assign guardianship to other people, but my understanding is it's a super high standard. There's a presumption that the parent, whether you're the biological parent or not, is in the best interest of the child. And you have to prove by a preponderance of the evidence that there is a serious harm and being done to the child by having this person continue on as the parent. It's a really high standard to take away parental rights. And so far, there are no cases I know of where it's been taken away because of gender identity or sexual orientation. And let's hope it never goes there. But I would not be shocked if a hostile state started to do stuff like that, which is why you don't want to move to Texas. But anyway, we won't go there.
Well, let me ask a final question that combines a few of our participant questions. This is from someone who just got married last year and they're submitting their taxes together for the first time. Is there a checklist for what they should do to update legal documents? And then in general, any books or resources that you would recommend for folks before they engage the services of a professional?
Yeah, all great questions. Well, there is just an endless number of resources in our AI world of ChatGPT. You can start there, and it'll mostly be right, actually. Um, in terms of a checklist, go to any website or competent lawyer and they can give you the checklist. But, depending on your wishes and your asset situation, your tax situation, you should either do a will or a trust and then do your power of attorney and healthcare proxy and HIPAA release and maybe designation of agent for remains and other things like that. So my checklists are in the materials. Other people have them. Ours is on our website. Um, in terms of filing jointly for the first time, talk to an accountant. There are ways to optimize things. There are ways to mitigate exposure, and it really depends on what your earnings are and what your assets are and what the cost basis is and how things are happening around your economic life. But that's really a question for an accountant, not a lawyer.
Got it. And I trust that we will circulate the recording, perhaps if you give us permission, the full slide deck, including the ones we may not have had chance to review
For
for those
sure.
who signed up. So I want to thank Scott on behalf of the Boston Public Library Fund and certainly all the active participants for sharing your knowledge and expertise. It's clear that getting married is not free, and yet the public library is free to all. And so I'm grateful that you've helped us provide information that really will equip us to protect the people we love. Thanks to all of you for participating, and I hope you stay involved and be a part of the future of our beloved Boston Public Library. Bye bye.
Thanks, Peter.